Okay.
I'm happy to kick it off with the intro whenever everyone's ready.
Okay. Go for it, Lucy.
Amazing. Good morning, everyone. Thank you so much for being here. My name is Lucy Resar, and I am a program coordinator in AmeriCorps Vista at Pennsylvanians for Modern Courts. And I wanted to thank you all on behalf of our organization for joining us. And thank you so much to Dick and the Free Library for hosting us this morning. If you have the chance to fill out the pre-presentation questionnaire, I put the link in the chat, and that really helps our funding. And you'll also be entered into a raffle for the chance to win a Starbucks gift card. And for those of you who don't know, I'll provide a brief introduction to PMC and our wonderful speakers. Pennsylvanians for Modern Courts is a nonpartisan nonprofit that envisions a Pennsylvania judicial system in which everyone is assured impartiality, fairness, accessibility, and respect. For 35 years, PMC has worked to educate, all Pennsylvanians about the courts and how to navigate them with confidence. PMC aims to provide resources to make that possible for all residents of the Commonwealth. While we will not be providing legal advice this morning, we hope that the presentation will be an informative and educational experience for everyone here. We are so honored to be joined today by the Honorable Greg Yorgey-Girdy and PMC's President, Deborah Gross. Judge Yorgey-Girdy is an experienced attorney with nearly 2 decades of law experience in Philadelphia, focused on litigation conflicts and compliance. In January of 2022, he assumed office as judge of the Philadelphia Municipal Court, and earlier this year took over as civil supervising judge. Debbie Gross is the CEO and president of PMC and came to the organization with over 35 years of private legal practice in federal and state courts all over the country, concentrating on complex commercial litigation. Debbie has served as the chancellor of the Philadelphia Bar Association and has focused her advocacy work on judicial independence and empowering residents with legal resources and education. We are extremely grateful to both Debbie and Judge Yorgey-Girdy for joining us today and sharing their extensive knowledge. We hope you all enjoy, and thank you for tuning in.
Thank you, Lucy. And so I am going to share my screen and hope that this all works smoothly. Let's see, and I have to go to the beginning. Home.
And it looks like, Debbie, we have 2 people that raised their hands. Do you want to take a question now?
Sure, why not? We can do that. And then we can start, no problem. So I think we're going to put the questions in I thought we were putting the questions in the Q&A or in the chat. Because I'm not sure we'll be able to hear them, given it's the webinar, how the webinar is set up. So maybe if you could put your questions in the chat or in the Q&A, that would be great.
I also allowed the 2 people with their raised hands to speak as well. So either they can unmute or use the chat.
Catherine, do you know that your hand is up? Maybe you don't realize that. All right, let's begin and put your questions in the, oh, go ahead, Catherine.
No, I don't have a question. It's in an error.
Okay. Thanks. No problem. Computer tech. My 28-year-old son came home and I changed computers from an old one to a new one this week, and I was panicking. So I completely get it. So I want to say thank you to the Philly Library. Thank you to Judge Yorgey-Girdy for joining us. This is a conversation, right? This is no legal advice. This is a conversation about civil claims in Philadelphia Municipal Court. I'm going to go through the slide. Can you see the slides from the beginning? Can you see the slides?
Yes.
Okay. Okay, perfect. All right. So Lucy already gave a little bit of information about us. And this is for the questionnaire. And once again, if you can fill it out, believe it or not, we have a lot of grant applications that ask us information about who watches our presentation. So you help us continue. So thank you very much. So these are upcoming programs. We will also provide a copy of this PowerPoint to the attendees after this program. And you can always go on our website, www.pmconline.org, to see recordings. We have a YouTube channel. We record all these programs and many others. So, you know, you are welcome to peruse our our website, I will say. Okay, so where do small claims court or claims fit in, right? This is our famous triangle for Pennsylvania. Our highest court is our Pennsylvania Supreme Court. It takes very few matters, I will say, a small percentage of matters that are filed in Pennsylvania. You should know that most cases, right, are filed in state courts. State courts are different than federal courts. We hear a lot about the Supreme Court, and that's typically about the U.S. Supreme Court. You don't hear as much about the Pennsylvania Supreme Court, although we have made news recently because unfortunately there was a cyber attack on our Pennsylvania Supreme Court, pretty close to in timing a decision that they issued with respect to I'll say Medicaid, Medicare funding for abortions. So our system's up and running, but we always have to be on alert, I will say. And even Philadelphia, which has a court system, has a separate computer system, probably over 5 years ago, right? Judge Yorgey-Girdy had an incursion, I will say. So it's not easy to be in the court system. So our highest courts are Pennsylvania Supreme Court. Under that are our intermediate appellate courts. They are our Pennsylvania Superior and Pennsylvania Commonwealth Court.
Can you hear?
Oh, Catherine, I need to. We can do that. I got it. Okay, so and those are our intermediate appellate courts, and then below the intermediate appellate courts are the Court of Common Pleas. In Philadelphia, our Court of Common Pleas is known as the First Judicial District. It is the largest Court of Common Pleas with the most number of cases filed and trials in the entire Commonwealth. And then below the Court of Common Pleas is the Municipal Court, which is what we will be talking about. In Philadelphia, we are unique in that we have outside of Philadelphia and all the other counties, there are magisterial district courts. So, okay, I see Judge.
The only thing I want to add to that, though, is that Pittsburgh, Allegheny County also has a municipal court.
Yes.
However, they don't use it.
Well, I'm going to explain it the municipal court judges in Pittsburgh are also magisterial district judges.
Yes.
And an MDJ, so everybody knows, doesn't have to have a law degree, but has to pass a test and take continuing judicial education programs courses. Whereas judges in Philadelphia in municipal court, and Your Honor, do you want to talk a little bit about municipal court?
Yes. As Deb was saying, in municipal court, you do have to be you have to be a lawyer in order to run for municipal court. I practiced, for a long time before that. One of the things I love about municipal court is I consider it a people's court. And the reason why we say that is because sometimes it's the first experience people have in courts through our courts, either through small claim court, landlord tenant, or through criminal court, which we get all of the preliminary hearing cases, and we also hear misdemeanor trials in our court.
And so decisions that are made in municipal court can be appealed to the Court of Common Pleas. But as the judge has said, the municipal court is divided into 3 different divisions. Do you want to briefly go through them?
Sure. We do have since we have the slide up, we do have a traffic division. We sit in the traffic division, which is actually really well tuned machine. It used to be a separate court. Then we took it over. Actually, I think it went over the Court of Common Pleas. Then the municipal court took it over. So we hear cases in that court. And if you want to appeal that, it goes to Court of Common Pleas. The caveat with that is is that we as municipal court judges sit as common pleas judges for the appeal in that court. That's what makes it a little different. The next section is the the civil division, which is the division I supervise, and that includes landlord-tenant issues. That also includes small claim issues. That has a limit of 12,000. Anything over 12,000 is something that you have to go to Court of Common Pleas. But we take anything up to 12,000. In the landlord-tenant realm, it doesn't have to have any. I don't think it's a limit to that. In fact, I had a case where an award could have been for $47 million. I'm not going to go into the details of that, but I could have awarded that case $47 million. And then we have
that would have made headlines.
That would have, and also just for a note, I don't make decisions based on the fact that I could or could not be in the headlines. But you best believe that was in the back of my head. And it was an interesting case. And we also have code enforcement, which not a lot of times we don't deal with it per se. We look at it to see if someone petitions for some sort of situation where they have to have a code enforcement issue, then that case is heard normally in front of a commissioner.
And the last division.
Oh, and also criminal. Criminal is also the supervising judge of criminal is Karen Simmons. She's the new supervising judge of criminal. In that division, we listen to misdemeanor. We hear misdemeanor trials, but we also do all prelims, and that includes felonies and misdemeanors. In that case, it's a very active case. We also keep a very active, robust violation of probation list, meaning that if we find someone guilty in a misdemeanor trial, they go on a list from us. And so if they actually if we sentence them to like 6 months probation or even jail time, if they violate that, we get a list and they have to come back in front of us. And that goes into long details on that, but we do get a list just like Court of Common Pleas. Now, all of these courts can be appealed to Court of Common Pleas, except for traffic court, which is also appealed to Court of Common Pleas, but we sit as Court of Common Pleas judges in that case. A side note, and this is new to you get a little new extra. In landlord-tenant cases, if they appeal our decisions, those typically go to Court of Common Pleas. In the past, we also used to sit as Court of Common Pleas judges to hear the appeals for landlord-tenant cases. And we are moving probably back to that. That is very new. It may not happen, but it looks like it may happen. We're in negotiations for that. I think it's important because we deal with landlord-tenant cases quite a bit, probably a little bit more than Court of Common Pleas. So I think we're better designed to do that. And it also relieves some of the caseload from Court of Common Pleas.
Thank you.
But I want to say this too, since we're talking about the courts, we do have a new administrative judge. His name is Yorgey Pittman. He used to be the supervising judge of the criminal division. This is the first time, I believe, in 30 years that we've had an administrative judge in municipal court. I think he's doing a wonderful job. He's a wonderful judge. We also have a new president judge, which is Fran Shields, who's been on the bench for quite a while. He is our new president judge, which he replaced the former president judge, Pat Dugan.
And so these titles are important. President judge is elected by their peers, and they sit for 5 years. Is that correct, Your Honor?
That is correct.
Right.
The administrative judge is appointed by the Supreme Court, which Judge Pittman was appointed by the Supreme Court. And Judge Pittman then appoints his supervising judges, which he appointed myself and Judge Simmons, me as supervising judge for civil division, and she's supervising judge of the criminal division. And as a president judge, what the president judge does is kind of oversee the landlord-tenant area in small claims, and also they do some other administrative issues that I'm not quite certain of, which I will learn in a couple of weeks because we have several meetings coming up. And the reason why I don't know is because it's kind of new. The president judge used to do all of this, and now these are new roles since we have a new administrative judge.
There's
Judge
somebody.
Yorgey-Girdy, this is Judge Shields. I don't know if you can see me, but I'm here.
Oh, there he is, our new president judge.
But don't say
Wow.
bad about me because I can hear everything you're saying.
And I'm glad you showed up because I was just about to say something so negative. So thank
Wow.
you for that.
This is a special treat. Thank
So
you, Your
our new
Honor, for
president,
joining
Judge.
us.
You know, my wife never says that when I come home. Like, but yeah, I'm happy to be here. I was anxious to see Judge Yorgey-Girdy in his screen debut here. We're really lucky to have him taking over the civil division of our court. It's really an incredible part of our court for all the reasons that he's just mentioned. It is the people's court, and I think we do good things in that court for the people of this city. And I'm anxious to see how it moves forward under his direction because he's just taken the bull by the horns. I see the horns hanging behind him on the wall.
Absolutely. I'm a Longhorn through and through. And
He's a
Judge,
long-
just to be fair, it shows your name as my secretary,
Yeah,
Angelica
that's what I was
Davis.
going to say. You have the same. It's the same with you. I mean, I know that you're not Angelica Davis, and I am certainly not Angelica Davis. So
Well, we like to go incognito just in case someone wants to file a complaint based on our presentation here
yeah,
today.
somebody might want their money back. Yeah. But
Well,
anyway,
I also-
thanks for having me.
Thank you for joining us. And I also want to emphasize that this is what is so wonderful about our courts.
Oh, we lost him.
Humans, that they want to help us all, and help, and that judges are approachable. One of the purposes of these programs is to show that people shouldn't be afraid to go to the court, shouldn't be afraid to respond to summonses or attend hearings, that this is an important job, that important part of going to the court, and that you're not necessarily going to be reprimanded by a judge as soon as you walk in. And as you both know, in municipal court and small claims court, a lot of the matters are by individuals representing themselves.
Right. That's
Yeah,
true.
and that's why I think these types of events are really, really important because they are represented litigants. And I know President Judge Shields and I are working to make sure that our court, particularly the civil division, is accessible to all people. And that's why I say particularly civil division, is because that's mainly where you get the self-represented litigants. And to be quite frank with you, as a lawyer and as a judge, when I first came on the bench, just looking through our website and looking through what you have to navigate, it's difficult as an attorney. And just imagine if you're someone who just got some sort of summons or some sort of complaint, and you don't know where to go, you don't know what to do. And I think our job is to make it easier, more accessible. And not everything's going to be easy, and we're going to make mistakes. But I think I can speak with the president judge that we do listen, and sometimes what we get is not what we want to hear, but we're here to make the courts better. We're not perfect, and we know that, but I think our goal is to aim for perfection, and that's what we're trying to do.
And I guess following up on that, and thank you, and following up on that, there's a lot of legalese that make me, even as an attorney, uncomfortable, right? So, don't be afraid of it, right? We have some terminology here that's sometimes referred to, typically burden of proof, right? You hear that a lot. You can hear that on television, but it is common sense, right? Preponderance of the evidence beyond a reasonable doubt. We like say preponderance of the evidence, it's greater than 50%, right? So, these are legal terms, but the judge will explain, if you are in court on your own without an attorney, what is required of you as a plaintiff or as a claimant or as a person bringing the matter, and what is required of you as a defendant or the person defending the matter or the person who has been accused, right, of causing the injury. Now, keep in mind, even though a complaint is filed, it doesn't mean that's proof, right, of the fact. So these are just a few terms. I don't know, Your Honor, if you want to address any of them, or we can skip on to the why go to civil claims court.
The only thing I would add on these is that, and I can't speak for Judge Shields on this one, but when I have a self-represented litigant, I go through and I try to make it as plain as possible, but go and make sure we stick to the law. Sometimes they have questions, but I actually kind of put myself in a role as an attorney in that situation, but still being impartial, especially when the other side has an attorney, because I need to make sure that person, it gets their case out fully. And sometimes when you explain things and you put out terms, it kind of even makes it more confusing. So I try to make it as simple as possible. These terms right here, I think anybody that comes into the court, they're not worried about that. They're worried about making sure they take care of the situation. So we deal with their personal situation or the case, and just deal with that and explain why they won or lost, and go through those reasons. And I think they can understand it better personally than kind of describing what the terms are up front.
Right. And the other thing I want to add is that, going to court is emotional, right?
Yes.
It is, you are, I mean, even when I have gone to court, we were in a car accident many years ago. It is emotional, even as a lawyer. So you just have to remember to try to keep your emotions in check. You should, landlord tenant matter, you've been kicked out, or you're not getting heat, you need to, or not, you've been kicked out, you have there's a complaint for eviction, but you have to wait till the results of the courts. But you have to try to keep your emotions in check and convey the facts of the situation, right? We don't want any anger. There's a possibility of a judge putting you in contempt of court. In the courtroom, there's not only judges, but there are there's security, there's other parties, there are parties who are there, for other matters. So it's important to make sure that you keep, you present yourself in a professional manner. So why we briefly touched upon this, but John, you want to go through some what claims can be filed municipal court and what can't?
Well, we'll start with the small claims, and you have it right here on this sheet, and I think I went over it earlier. Most claims that if a claim was considered a small claim is anything under $12,000, and that's for a small claims case. Anything above that should be filed with the Court of Common Pleas. The only exception to that would be the landlord tenant. So anything it doesn't have a jurisdictional limit, I believe. Judge Shields, you can actually correct me if I'm wrong on that.
Yeah, no, you're right. It doesn't have a limit with regard to the landlord tenant cases. The limit in terms of the small claims, which are usually, typical contract cases. Somebody's suing the contractor that they hired to put their kitchen in or put a roof on their house. They're the typical cases that we run into in small claims. We also run into an awful lot of credit card cases where the credit card or whoever was the ultimate debt buyer relating to a credit card is suing somebody for not paying their credit card bill, those sorts of things. One of the things that I think you have to remember, and it's important for everybody to remember, especially the judges, is that when you're dealing with these cases, just the name of this, small claims, you have a tendency to think that it's not so significant, right? People refer to us as a minor court. Just because of the way people refer to us and these cases get referred to, people have a tendency to think that they are small, that they are insignificant. And believe me, there's nothing that I fight back against more than that, because, when I sit in landlord-tenant court and I have some woman who's a tenant who comes in front of me and she's a young girl and she's got 2 or 3 kids and she's raising these children by herself and she's a tenant in a property and she's got a landlord that technically did everything by the book, but the truth is the place is a mess and he won't fix it up. Based on the rules and based on the law, he's not really violating anything. But in the meantime, that decision that I'm making right there in that so-called minor court may have the biggest impact on the lives of that woman and those children than any other decision that's made in their life. That's a huge responsibility. That's a huge burden. And my belief is we're making those decisions. Our judges are making those decisions every day, half a dozen times a day. And to me, that's a heck of a lot more major, to use that word, than some $40 million case against some corporation that made a weed whacker that went crazy. Our decisions they're making are having the biggest impact on the people of this community than any other decisions. And it's a huge responsibility, and it's something that you have to take seriously, despite the fact that, at least on paper, it appears to be something minor.
Oh, sorry, Your Honor.
No, the only other thing I was going to say is, so when you have those cases, and typically, as Judge Yorgey-Girdy said, we're going to run into situations where these people are not represented. Your obligation as a judge kind of changes, and you got to play a different role. You got to recognize that these people are not represented, that the other side is, that puts them, kind of one step back right to start off with. And so you have to try and figure out how to keep that in mind when you're moving forward in the courtroom under the rules that you're required to move forward under.
Thank you. And the other thing I want to emphasize here also is that you shouldn't ignore the receipt of a complaint, of a summons, because that too has a serious impact on somebody's existence, right? On somebody's life. If you ignore a complaint that's filed, it can lead to a default judgment. And so it's important to come to court, not be afraid to come to court. And as you see, judges are want to hear the case, want to hear the facts, and decide the law based on the facts that are presented. So it's really important to not ignore anything that comes from the court. That's what I will say.
Said, Deb. And I want to add for both you and Judge Shields, particularly in the credit card debtor situation. I know things that happen. You get this complaint in the mail. You get served with a complaint that said you owed something from Credit One, and Credit One sold that debt to somebody else, and you get this, and you get a lawsuit saying you owe $750. Some people are so afraid by that and scared, and they put it aside and they put it away because they've never been to court. They may know they owe that $750 or may not owe it, but they put it aside, and so they get a default judgment. One of the things that we're looking at in that courtroom, that's courtroom 5, is that we have such a high default rate, and we're trying to look for the reason why. A lot of times it could be service issues. They probably weren't served correctly. They didn't know about it, or maybe they were served correctly and they were scared. So Deb, you brought up a good point. Don't be afraid to come in, because what we see is if you do come into court, a lot of times the people that are on the other side, the debtor, normally works with you, almost cutting that debt in half and having you make payment arrangements. So you can get that off your credit. So when you buy a house, when you want to buy a car, it's off your credit. I think a lot of times, even though we call it small claims, these are major issues in people's lives, particularly in people in this city that has such a high poverty rate. So $750 to somebody could be like millions to somebody else. So that's really, really important. And we keep that in mind when we're on that bench.
So I'm going to skip ahead. So the other thing I want to emphasize, because Judge Yorgey-Girdy just said this, is failure to show up, failure to present an argument could result in a record that follows you for a while. So it's a credit card debt, it's housing. It could be hard to get additional housing if you have a judgment. So these are really important matters that should not be ignored. So, we have a little bit of history here about going to municipal court, how you file a claim. First and most important is better gather your facts, right? Make sure you have all your information. I can't say it enough. Documents, evidence, pictures, emails, texts are really important. And print them up. Don't show the judge your phone, but print up the documents, attach them to a complaint.
Oh my God, and I don't know if the judge can tell you this too. I personally don't like getting phones from grown people because I've had phones in my hand with photos that you do not want to see. And it's not the evidence that they wanted to present me. So I don't like that. So please print those out. But all kidding aside, it's really, really important when you come to court, and this is a small thing. If you do come to court and you have your evidence, someone says, Judge Shields tells he sues me for $2,500. And I paid him that $2,400, and I paid him by Venmo. I Venmoed him $2,500. I'm coming to court with a printout showing that I paid Judge Shields for a lobster dinner 2 weeks ago. And I come to court and here, Judge, here it is. Judge Shields says, oh, okay. You have to present your evidence. It's important to have that. So many times we have cases that come in and the litigant, self-represented litigant said, well, I don't have it with me. I left it. You have to come to court. And so this is why I do these programs, is to make sure you bring any and everything. I'm willing to look at anything that helps you with your case. It's important. If you have some sort of evidence, it helps. I had a case the other day, not to get into details, but she had a lease and she had brought her old lease with her. That old lease proved that they were suing the wrong person. And I said, good for you, good for you. And it made a whole difference. So it was a defense verdict just on that case because this person brought everything. She had a big file folder full of documents, and that evidence right there made that actually it wasn't a defense verdict. The plaintiff actually withdrew the case, and it was done.
Great.
So it really helps when you bring in all your information.
So the other part is you should have a general understanding of law. Now we don't, you're not expected to know cases that, go do research on cases, but, there are certain basic principles. Was there a contract? Was there an agreement? Was it written or unwritten? Who's involved? Who's suing whom? I mean, who injured who? What are the damages? I mean, you can't just file matter in court because you want to go to court. There has to be a legal basis for filing the claim. The recording just stopped, Lucy. I don't know what that means.
And I also want to add on that too. If you do file a cause, particularly if you file a claim with small claims court, we have, which is headed by John Joyce, we have first filing that do a wonderful job of actually helping you. They're not going to give you legal advice, but they kind of walk you through the steps of what you need to do. So I know they do a great job with that. So that's also helpful.
So what you do is you don't have to have the complaint prepared ahead of time, although it definitely will help. Okay. Complaint forms are available online. This is a Court of Common Pleas form right there. It's not a complicated form to fill out. But you need to write who the plaintiff is. That means if you're filing the complaint, who you are. You need to write your address. You need to write who you're suing and their address. And you need to explain in general, right? It's not, as you see, there's a box there. It doesn't even expect a lot of information, but you can attach, a summary, claim. And I'm trying to not use legal words here. You can attach a list of what you think has been the violations that have occurred. If you have, for example, the lease, attach the lease agreement. If you're suing a contractor, if you have an agreement with the contractor, even if that agreement is in an email, you can attach it to the statement of claim to file it. And again, as the judge said, the court cannot give you legal advice. It can answer some questions, but it cannot give you legal advice. And that also applies to those in the clerk's office. Okay. Right. You have to sign it. There are filing costs. If you cannot afford to file a complaint, there are forms that you have to complete to show that you cannot afford to file the complaint. Anything else, Your Honor?
No,
Your
and
Honor.
we do use these legalese, and I can't even pronounce a word. I call it an IFP, which is informa paupers.
Yes.
I want to change that to fee waiver. I think everybody in the world understands what a fee waiver is. I'm going to waive the fee. So we're looking at stuff. Me and the new PJ Shields are looking at things like that. Like we use documents that say that. So if I give you a document that says an IFP on it, you don't know. It actually to me sounds like some sort of medical term. So
Yeah.
just to say the term fee waiver, or better yet, just put it in parentheses. This is a fee waiver. So we use that. Now, there's certain criteria. I'm not going to say you're going to automatically get that, but certain people, and particularly in this city, need to have a fee waiver. They can't afford to file a defense or some sort of petition to reopen a case that they didn't show up to, which is called a default. So we have that form there, a fee waiver form. You fill it out, and so you can do this for free. So that's important. And I also want to add too, because we didn't say this, in certain area codes, and I don't have them right offhand, in landlord tenant, you do have a right to, based on the city council, they provided funding to have lawyers. We have lawyers of the day that will help self-represented litigants go through that, because it is a big situation when you are faced with losing your home, whether it be a home or apartment. I consider those homes. So we do have attorneys available for that, but you have to ask for that. When we come in, we have what they call navigators that come in and they'll ask situations. Then you're interviewed to see if you are eligible to receive the lawyer of the day, which can help you through that whole process if you're in your day in court.
The other thing that's important to know is that Philadelphia has a very robust legal nonprofit community. And so it has a number of organizations that definitely are swamped, but still can help you navigate this system. So there's, community legal services. There's, oh my goodness, why am I drawing a blank here? There's just a highest, there's WHIP. And to find out which CIP, to find out, even to figure out which legal nonprofit you need to go to, you could actually go to the Philadelphia Bar Association's website, and it has a list of, there's over 30 different legal nonprofits. Plus, in addition to that, like Philadelphia is, if unfortunately, I said this, if you're in trouble in Philadelphia, is the place to be, because we have a number of law schools that also have clinics that will help you. So that don't give up hope. There are resources out there. It's just a matter of trying to navigate to find them. Okay.
Can I emphasize something that Judge Yorgey-Girdy mentioned, and that is that the staff that we have down there, I mean, they're dedicated people and they're professionals. They do a great job. And one of the things that they really do a great job at is in the first filing unit, when people like the type of people we're talking about now come into the first filing in order to file their claim. Our people down there are well aware of what has to be done and how it has to be done, and they bend over backwards, as we've already pointed out. They don't give legal advice. They can't give legal advice, but they will sit down and listen to that person's story, and then they'll tell them, well, this is how you want to frame your complaint, and they'll go through the complaint with them and tell them this is the kind of information that you want to put into the complaint so that it's done properly. And in that way, I think they really go out of their way to make the process a lot easier, a lot more comfortable for the people that are coming in who are in this kind of situation where they're frightened, they're unsure, they don't know what they're doing, but at the same time, they're dealing with something in their lives that's awfully important. So I just wanted to emphasize that our people down there at First Filing do a terrific job in that respect. They go above and beyond the call of duty in terms of making these people feel comfortable and helping them put their claim in a way that won't bounce back for some reason or won't get treated in a negative fashion.
And that's important because oftentimes the filing a complaint is last resort, right? People have tried in so many different ways to resolve the matter, and they just haven't been successful. So therefore, going to court is really, I like to say, your last resort. And so people are there's not a lot of time sometimes, or this is, the money has been lost, or the harm has occurred and the damage has occurred. And so, you don't want, you can't, delay would not help you. So it's important that, that you can go into this first filing unit and they will help you. Also, if you don't speak English well, or if you have a disability, the court system has resources to assist in filing when you have those disabilities or language barriers.
And I want to add to that too. Even if you go into court, even if the first filing does a great job, and let's say we go into court, it's the day of your hearing, you're very nervous, you walk in, you expect to come in because you watch too much of these court TV shows. By the way, I don't watch them because it's not real life, but people love to watch, especially my mom. But what happens truly in court is, before you even go to court, what tries to happen is a mediation. We have a great mediation team that works with both parties, particularly if both parties are self-represented. They go in the back and they have a mediator to try to resolve the situation before you even get to a judge. And a lot of time, I don't know the numbers here, and maybe Judge Shields does, but I think a lot of those cases wind up become resolved just by just having an impartial person that's not a judge, and it didn't even go to trial, to resolve the situation then and there. So that, I think, also, I like to say that because that also relieves some of the folks' tension about trying to come to court, because a lot of times these cases are resolved. The ultimate goal is not to go in front of a judge, because that can be intimidating, particularly if you have someone like me who is probably mean and loud. They prefer to probably mediate this and not go in front of me. So I wanted people to know that you don't always have to go to trial when you go to court. It's normally resolved before you even go to get in front of the bench.
Thank you. And mediation, I also say, is often it helps people who are on high alert, right? Who are emotional. There's this impartial individual before getting to a judge who maybe can see things from a different light and will help you and the person you're suing, or resolve the matters. So once a complaint is filed, the next process is that the complaint actually has to be served, right? If you are suing somebody, that person needs to know that you are suing them. Or if you're being sued, you need to know in a formal process, okay, that you've been sued. You can't just have heard from somebody that you've been sued. You actually the service has to be made, and the court will require proof of service. Your Honor, do you have anything to add to that?
Not necessarily. I think that proof of service, particularly with self-represented litigants, it's very difficult for them to understand what that is and how that's done. And again, our team in first filing helps out quite a bit with that, because there's a little nuance between, if you're filing something for small claims, that it has to do with just small claims, as opposed to landlord-tenant. Now, typically, when you serve somebody in landlord-tenant, you're a landlord, but you have to understand, not all of our landlords are represented by attorneys. Some of those folks are people that are self-represented, and so they need to know what the difference is. They can also post the complaint as opposed to small claims. So they're small. I don't want to get into all the details with that. What I'm trying to say is that we do have a team of folks at first filing that will help you go through that and tell you what you need to do. And not only that, not to give you legal advice, but they also tell you up front if that you may need to do this again, or the service may not be proper.
And so when the service is made, it will also include a notice that you're supposed to respond to the lawsuit, right? The services of the complaint, and talks about how you should respond to the lawsuit. Whoops, what happened to that? Okay, that's, so there, that also gives you a date for a hearing. So you need to show up, but you need to respond to the lawsuit as well. You could file a document in court, providing your position, right? The response is your position to the claims against you. You can provide documents supporting your position. You can also bring a counterclaim. That's another legal term. It means that you could, turn around and sue the you as the, I'm using these legal terms, I don't like it, the defendant or the recipient of the lawsuit can turn around and sue the plaintiff for something, the person who's suing you for something that they did wrong. So again, these are your various, these are out of order. I'll put them in order next time. So those are your responses to the lawsuit, but then you have a hearing. The court will set a hearing where parties are expected to attend. It's important, if you can't make this hearing, not to not show up, but to actually call or send a letter and say why you can't make the hearing and ask for it to be rescheduled. Your Honor, you want to add anything to that?
No, I want to just reiterate what you said. It's really, really important. Things happen. We just got out of a pandemic. Some folks are still suffering from COVID. So we don't want them coming into court. If you have the flu, we don't want you in the court. As soon as something comes in, I don't know what happened. I think people get afraid. Call the court, write the court, email the court, let them know I cannot make it because something happened with my kids. That happens all the time. I typically grant those and or have a continuance. We also have done telephonic hearing, particularly with people that have certain disabilities. We try to make every effort to allow people to bring their case in and make it comfortable for them. But the key is to this situation is to make sure the court knows what's going on. It's important that you just notify the court because you can't just show up and say, well, I was sick. Well, you got to let us know. Just notify the court you can't be there.
And the other thing that's important is don't call the court the day of the hearing. Make sure you call the court, send the letter ahead of time. If you know that you're not able to attend that hearing, make sure you give the court as much advance notice as possible because it's really important. Okay. So we discussed this briefly, but this is when you get the complaint, the hearing is a real hearing. This isn't something where the court is just introducing you to each other. This isn't something at a point in time. This is a real hearing. The court is going to hear the evidence and make a decision. And so make sure that information is brought to this hearing. Your Honors, you want to add anything to that?
I think you put I said this early. It's really important to bring any and all things to court. I like to look at anything that you have, particularly if you have a certain defense. If you have receipts that you've made payment, or you have some sort of email text chain that shows, this was the sort of agreement. Particularly, I'm thinking of cases where we do get a lot of cases where, like home improvement, what do you call it? Construction cases where someone comes in and hires someone to remodel their kitchen. And this person is suing because they gave them a credit card to Lowe's, which I didn't know they did that. Apparently, that's a new thing. When you're doing a remodeling project, you give someone a card. I didn't know this. And I learned this quickly. And this person takes out certain amounts of stuff, and that person has the plaintiff has an itemized list. And so I had a case where someone was suing because they were buying these extra things that weren't with the project. And she was actually amazed. She was self-represented, and she pulled all that out. She had a dramatic little, it was highlighted. She showed everything that was negotiated in the contract and pointed out the stuff in a different color that the contractor purchased that wasn't with that contract. It was amazing. And so she won. So that's an example of bringing in information that you need in order to win your case or even to defend your case. Oh, Judge Shields, do you have anything else you want to add to that? Because I know I was pretty brief on that.
No, I agree. I agree with everything you said. It's important that they bring everything that they can bring in. But of course, again, you have to remember, some of them don't know what's
Yes.
important and what isn't, depending on the claim. And so, you know, it really is a difficult challenge for our judges to handle these kind of cases where you have people, you have to make sure these people get their day in court, whether they're a defendant or they're a plaintiff. And at the same time, we do have rules and regulations and statutes that we were obligated to follow. So, you know, we're always kind of walking a tightrope, sometimes stepping over the line and pushing the envelope, for to use a different analogy, as much as we can to make sure that these people get their fair hearing. But at the same time, recognize that, you know, the other side is entitled to a fair hearing too, and we do have these rules that we have to live by. But you know, the best advice is what both of you have just given folks, and that is bring everything that you have that you think relates to this case, and when we get there, we'll sort it out and figure out whether it's supposed to come in or it's not, or whether it really does have an impact on the case or it doesn't. And I find that in situations where people do bring things in and you come to the conclusion that it's really not relevant, or it really isn't something that should be considered with regard to whatever the particular claim is. If you explain that to people, you know, you want to make sure that when they walk away, even if you rule against them, either on an evidentiary issue or on the case itself, that they walk away feeling they got their day in court. They had their opportunity to put their case in front of you. They had their opportunity to tell you what they wanted to tell you. And oftentimes, even though they may be disappointed with the outcome, you know, they recognize that they got that opportunity. And of course, you know, the other thing is, as always, they have the right to appeal for a trial de novo in the Court of Common Pleas, which, you know, that presents a whole other issue for them. But at least they got their day in court. And so, you know, the short answer is, the best advice is bring everything you think, you know, bring the kitchen sink in if you think it applies, and we'll figure out whether it does once you get there.
And also witnesses, right? You can't go to court and say, well, my neighbor saw this happen. That won't cut it. But if you can bring your neighbor in, that would be very helpful. If you can't bring your neighbor in, but you could get a declaration from your neighbor signed, you know, under penalty of perjury, signed with a notary, maybe, you know, that may be admissible, but it's really important. It would be much better if you could have the witness come to court and support your position.
And you know what, that may be admissible, and it's good to have if you cannot bring them in.
Right.
But the important thing about that is timing. Make sure, if that's something you're going to do, make sure you get that to all sides at that time. And that we're getting kind of into something more difficult, because I think that's the more sophisticated, actually self-represented litigant, because typically what they'll do is just bring in that party. They don't have a signed affidavit on that. So if you're doing that, you pretty much know what you're doing in this situation if you brought in a signed affidavit. So I'll just leave it at that. But most people do bring in witnesses at the time of the hearing, and we'll go forward with the hearing.
So where's the courtroom, right? It's not in City Hall. It's not in criminal court. It's in a different building. It's at 1339 Chestnut Street in Philadelphia. It's on the 6th floor. There is security. You need to make sure that you give yourself time. If you have a hearing scheduled for 9 a.m., aim to be there at 8:30 a.m. Make sure you are on time for court. It is really important. Right. It shouldn't be late. And there is an expectation that you will follow certain rules in the courtroom, right? Come prepared with your information. Maintain your composure. Dress appropriately, I will say. Don't interrupt, you know, treat the judge with respect. It's really important. Every little thing matters. Your Honors, you have any comments?
Yeah, I the thing with that is, I just expect people to treat all people with respect, not just the judge. When you come in, we have a great team of folks that are working, and they're doing their best to get everybody their day in court. And I see things that happen, hear things happen, and people upset. And I understand you have a case there, you're upset, you are wrongly accused or sued and you're angry, but you have to be mindful that person that's trying to help you get to where you are is not involved in that case and they're trying to help you. So I think being respectful to all people is good. And also, it's where I was raised. It's common sense to be put yourself in the best light, particularly when you're getting ready to go in front of a judge, and he or she is going to make that ruling. It's not smart to maybe cuss them out or say things because maybe a credibility issue comes in there. And it makes me laugh sometimes when I see people who are they just start off just angry. Now, I'm mindful that you have to put yourself in their shoes. They may be angry. So we try to do a calm down kind of situation, or what I call it a reboot. Let's start this again. This is what's happening. I realize you're upset. And typically that works, but sometimes it doesn't. And I'm a big fan of in that room, because we have so many people, you have to be careful and keep a tight room because other people are listening. We have to look at all kinds of different things. Just be polite, be patient, because we're definitely trying to get people out of that room and make sure everybody's heard.
So that's an interesting point you make, right? When somebody comes to court, their case is not the only case that you're hearing that day. So, do you want to explain, I guess, the process sometimes in the morning, how you go through your procedures?
Well, in the case we normally we come to court, the judges get on the bench a little later. And that's because first of all, the commissioner goes out and he stats the cases. Sometimes people don't show or they had some sort of continuance, a continuance by agreement. That means both parties decide that, we need a little bit more time. So those cases are moved out. So they move out all the cases to clear out the room a little bit. And then they also give the parties opportunities to go back and speak to see if they can negotiate some sort of settlement together. They work on point, and that happens a lot. And then if there's a situation where someone needs a continuance, they want to continue the case because they need a lawyer. They want to continue the case because they may have forgotten some document. The other party disagrees, then it comes in front of the judge, and the judge will make a decision if that case will go forward. And then once that happens, we slowly hear those cases. We'll bring in one case at a time. Me personally, I'll let my team decide what case comes in front of me, unless there's a case I call back and someone had some sort of emergency where they have to go out for childcare issues, then we'll hear that case first. Or if a case that has an interpreter, which we have a limited time with interpreters, so we call those first. What I'm saying is that there's certain process that we go. I do look around the courtroom and see who's there and try to ask, have you been heard? Has anybody helped you yet? Because I am mindful that people do have full-time jobs, they have childcare issues, and they need to go home. And so when I say, let's move these cases, it's not because I want to go and golf, which I actually probably do, but I'm not doing that for that. I'm doing that because I'm mindful that people have other things to do, like childcare and work and those types of things.
Yeah.
And so the judge, sorry. Go ahead,
can I just jump in real quick? I think a lot of what you had up there on the screen, it's common sense. When these people come to court, they have to recognize that they have to dress appropriately. Now, they don't have to show up in a tuxedo, but I had a case in criminal court where the guy came in for a hearing on a marijuana possession with intent to deliver case, and he had a T-shirt on with a big marijuana plant on the front of it. Not a good idea, right? He's kind of stepping his foot in the hole right off the bat. But if you come dressed appropriately, I think it gives the court and everybody else the impression that you're taking this seriously as well. Also, the other thing is, from the judge's point of view, our first job when we walk out there onto the bench is to what I'll call control the thermostat in that room. You've got to check out that room. You've got to look around. And as you have experience as a judge, you recognize the mood in the room. You can feel the temperature. You can see who may be problematic, maybe like Judge Yorgey-Girdy described, somebody who's already in a really bad mood and is going to act out or say something. And so you got to demonstrate to them right off the bat when you sit down, look, here's what we're going to do. We're going to do it this way. We're going to try and get everybody out of here. I want you people to, show the court respect. But I'm guaranteeing you're going to get the same respect from me. I'm going to treat everybody in this room with the kind of respect that I'd like you to treat me with. And usually, that does the trick. One other short thing I'd say about the one bullet point you had on there about addressing the court as Your Honor. Not long ago, I was over in small claims court, and I had a litigant who was very anxious and very scared, and it seemed like it was his first time in court, and he kept referring to me as Your Highness. And so after we were done, I suggested to my court staff that, I kind of thought it sounded pretty good to me, and I thought it was a pretty good idea. And from now on, we ought to be have everybody address me as Your Highness. Well, I got the same reaction from them that I would have gotten if I made the suggestion at home. They didn't go for it. So, the guy was just, he still had an awful lot of respect for the court, and he was frightened. And so I made a little bit of a joke out of it, and it took some of the hot air out of the room and calmed everything down. Of course, again, like I said, my staff, they just rolled their eyes and moved on. And needless to say, it's not going to happen again. Folks, I have to go. I'm sitting in traffic court. I have to get back down there for the afternoon session. I really appreciate you guys letting me sit in. But you're in good hands with Judge Yorgey-Girdy. He knows the system as well as I do, and he's been just a great addition to our civil court as our supervising judge. And I think that things are I think really good down there, but they're only going to get better with him there. And again, thanks so much for allowing me to participate.
Thank you, PJ.
Thank
Okay,
you, Your
guys.
Honor. It's
Thanks a
truly
lot.
a treat.
Absolutely.
Appreciate it.
Now, yeah.
There's just one or two more things I want to just point out. And one is that, the judge doesn't have to make a decision right then and there. Okay. I mean, you might want the judge to make a decision right then and there, but there may be reasons why the judge doesn't make a decision right then and there. One of the reasons is the judge wants to double check with the law. The other reason is that sometimes with the parties being so on such heightened alerts, it might be better for all of the parties, both parties weren't in the room at the same time when the judge issues the decision, but the decision gets sent to the parties. Your Honor, anything you want to add to that?
I'm glad you brought that up. Some judges are really big on that. Some judges do that quite a bit. And that it's called, I forgot what it's called. And the reason why I forgot what it's called, because I've never done it. Well, that's not true. I've done it once. And that's with that warrant with self-represented litigants. I am mindful that they came to court. It's difficult to park in our area. They are scared. I make that decision fairly quickly because I will do this. I'll remove myself from the bench if I have a question about law and research it quickly and come up, but I don't hold it at all. I just make that decision. But I'm glad you brought it up because some judges do that. And I think some of the litigants, self-represented litigants, get upset. They're confused about it because they wanted to make sure this is done with, but it does happen. I'm not one of them because I have a different philosophy. I think that I can make that decision pretty well. If it's a legal issue that I'm unfamiliar with, I typically have my cases prepped before I go out. I am an oddball, but you have to realize I was in private practice and worked almost 75 hours per week. So that's something I just do.
So there's one question, and I know we're really out of time. So I'm just gonna, it asks for small claims court, in the case of the contractor using a Lowe's card for items not used, this is also a criminal activity, isn't it? And so how might the contractor be affected by the consumer bringing them to court for the monetary value other than the need to return the items erroneously bought?
Well, we're getting to a lot of things with that, and that may not be the conversation for this group. Okay. I agree with you. We deal with, and I'm talking only on the civil side. On the civil side, we deal with it suing for the money that they owed. Now, they can also do a private criminal complaint right next door in our civil building with the DA's office, and then that is done a certain way. I'm not sure.
That's actually one that I wanted you to say. So it was, I wasn't, to me, the private civil complaint, right, can be filed, you can file. Also, if you, with the DA's office, it can also, and that may lead to the DA actually claims. So, you know, there is a lot packed into that one question, but the judge can only handle the matter that's before the judge. So if it's a complaint that an individual has brought against the contractor, that's all the judge will address. The judge will not address, you know, the criminal matter or the private criminal complaint. So we are out of time, and I can't thank you enough, Your Honor, for joining us. I love
pleasure.
these programs. Everybody, thank you for joining us. Thank you, Dick, for putting this on. Philadelphia Library for always being an amazing supporter. And the recording will be available on our website. We will send the copies of the PowerPoint out to you. And please don't hesitate to reach out to PMC if you have any questions. We can't give legal advice, but we can direct you to places that can. So please don't hesitate. And thank you.
Thank you, everybody. I appreciate it. Thank you for the good work.
Bye. Have a great day.
Thank you so
Hey,
much.
bye-bye. Have a good weekend, everyone.
You too.